Hi, I'm Jamal Jones, the founder and principal attorney at Jones Health Law, and today we'll discuss application for exemptions from disqualification for the Agency for Healthcare Administration. If you received a letter from the Agency for Healthcare Administration, otherwise known as AHCA, stating that they have uncovered criminal offenses that disqualify you from working for a healthcare provider, it can be a scary time for you. AHCA may have uncovered this offense through the result of a background screening submitted as part of the employment process for a healthcare provider and/or participation as a Medicaid provider. This applies to clinical staff as well as facility owners, administrators, and chief financial officers, and those seeking enrollment as a provider in the Florida Medicaid program. Fear not, because you may be eligible to file an exemption from disqualification if you meet certain criteria. First question is, am I eligible for exemption? Our firm can assist you with demonstrating to AHCA by clear and convincing evidence that an exemption from disqualification should be granted. The application will only be reviewed once all relevant supporting documents are received by AHCA. You're only eligible for exemption from disqualification if you have been lawfully released from confinement, supervision, or other non-monetary condition imposed by the court for a disqualifying misdemeanor criminal offense, at least 3 years after you have been lawfully released from confinement, supervision, or other non-monetary condition imposed by the court for a disqualifying felony criminal offense. You have completed any court-ordered fee, fine, fund, lien, civil judgment application, cost of prosecution, trust, or restitution as part of the judgment, and sentence for any disqualifying felony or misdemeanor in full. And if you have been designated as a sexual predator, sexual offender, or career offender, you're not eligible for an exemption from disqualification. Filing the application and filling out the application can be a bit tricky, so you should definitely hire a health law attorney that's experienced with doing so in order to prevent delays in processing your application. In addition to completing the application for exemption from disqualification, you will need to provide AHCA with the following: a current Level 2 screening, arrest reports, court dispositions, signed statement, only if you cannot obtain the arrest report and/or court disposition, probation and/or parole records, letters of reference, and documentation of rehabilitation. It is important to note that when you apply for exemption, you must provide all arrest reports, including those that were not specifically listed in the notice that you received from the AHCA. You will also need to provide all court dispositions, no matter the plea, judgment, verdict, or even if it was sealed or expunged from your record. All of these documents will need to be neatly organized, and AHCA must receive the documents within 30 days from receipt of its letter. It may take a little bit of legwork to retrieve these documents, so it is important to contact our firm as soon as possible so that we don't miss the deadline. AHCA rarely grants extensions for filing the application. Finally, if you are a certified or licensed healthcare professional, you may also have to file an application for exemption with the Florida Department of Health. Florida Statute 408.8097A states that AHCA may grant an exemption from disqualification to a person who is subject to the section and who does not have an active professional license or certification from the DOH, or has an active professional license or certification from the DOH, but is not providing a service within the scope of that license or certification. You may also have to submit a signed background screening privacy policy acknowledging receipt of the privacy policy. Once the DOH receives your application, they will review it and make a decision as long as that person is working in the scope of their license or certification. So what happens after filing? Once AHCA receives the documents, it'll be transferred to the exemption team and assigned to one of their analysts. As stated earlier, the analyst is looking for clear and convincing evidence that the employee should not be disqualified from employment. The agency will consider the following: the circumstances surrounding the criminal incident or incidents for which an exemption is sought, the time period that has elapsed since the incidents, the nature of the harm caused to the victim, the history of the employee since the incidents, any other evidence or circumstances indicating that the employee will not present a danger if employed or continued employment is allowed, and whether the applicant has been arrested for or convicted of another crime, even if that crime is not a disqualifying offense. Once you've submitted your application, it takes approximately 30 days for AHCA to render its decision to you. Exemptions granted by one agency will be considered by other agencies, but is not binding on subsequent agencies. It is possible for AHCA and DOH to deny your application even though you feel you meet the criteria for exemption. In those instances, our firm will represent you before AHCA and DOH boards if you choose to contest the agency decision. You have 21 days from the date you sign for the certified letter to request an appeal. The administrative law judge will only decide whether the agency's intended action is an abuse of discretion. Next question is, are you allowed to continue to work after your employer, after you submitted the application for exemption from disqualification? Well, it depends on the circumstances. If you were screened and hired by your current employer on or before June 30th, 2014, and this disqualification was due to a rescreening by the same employer, you may continue to work if you meet all of the following criteria. 1, you're eligible to apply for the exemption. 2, your disqualifying offense was not disqualifying at the time of your last screening, but is now disqualifying and was committed before the date of your last screening. 3, your employer agrees that you may continue working. And 4, you submit your application timely. According to Florida Statute 408.8094, an employee may continue to perform her duties and her employer may continue to allow her to have contact with any vulnerable person that would place the employee in a role that requires background screening while her application for exemption from disqualification by the agency is being processed and under review. You also must make sure that your license stays active if you are a licensed healthcare provider, which means that you should submit any renewal forms and correct any omissions to prevent your license from expiring.